Welcome back. In this section of the course, we're going to look at the common law. We've talked about the civil law. We're going to talk about the common law, and then we're going to do some comparing between the two. So what is the common law? Well, the common law is that Anglo American system, and it is based heavily on the court system, the practice of courts, what it is that the courts do. You often hear that the common law is referred to as case law. And we find forms of the common law in those places that were once occupied by the British. Former British colonies, such as the United States, Australia, Belize, Ireland. Some form of the common law is found only in those places today. The common law only exists where there was some connection to England. India, of course, a great example of a country of 1 billion people that is governed by the common law only because at one time England had India as a colony. However, having said that common law has been imposed essentially on the world by colonizers, the British. No country that has the common law system has been able or even willing to get rid of it. And that's kind of extraordinary when you think about how many former British colonies there are in the world that still use a form of British law. And as we'll see when we talk about the common law, sometimes there are laws that are derived from medieval England, and yet they remain the law of the United States in the 21st century. I think this goes to show the importance of consistency in the law, and that's the most important thing that the law does, is it provides consistency. So there have been no examples of a country that had the common law that gave it up and substituted the civil law. The common law, again, spread around the world in a very different manner. Again, you can find the common law used around the world in countries like India or in Central America and Belize and Australia. And it arose there through essentially conquest. The civil law tended to arise not from conquest but from choice. So the common law spread around the world in a very different manner than the civil law. The civil law generally was chosen. The common law was imposed. Now the common law has certain distinguishing characteristics, and one of the characteristics that you'll notice right away, it's a complicated mix of statutes and case law. So it's a mix of legislation, the law that comes from the legislature, and case law, the law that comes from courts. It's very different from the civil law in that sense, where in the civil law it's meant to be accessible. I can go look it up in a book called The Law, whereas in a common law system, I never know what the law is. I may have a statute that says what's the law, but I have to look at what courts have said about that statute. And as I pointed out before, common law tends to separate government and law, placing law outside of the government. Now, the common law uses the jury system, and I'll do a whole presentation on the jury system just because I find it interesting. The jury system is a feature that is not unique to common law, but plays a much larger role in the common law than it does in the civil law. The jury system, in which we say that a dispute should be resolved not by a professional, but by a group of people that resemble the people in the dispute. If you've heard that term, a jury of your peers, it means other people like you. In the common law, we believe that resolution of a legal dispute should not be left to professionals, but should rely on the good judgment of a random group of individuals that have no knowledge of the dispute existing. Common law tends to separate government and the law, placing law outside of the government. In civil law jurisdictions, as I mentioned, the law is created by the government. Now, historically, common law was divided into two aspects. What that meant is there were essentially two legal systems at play in a common law country. And those systems had their own judicial systems involved. Different courts applied to each individual legal system. We had a system called courts of law, and courts of law were concerned with legal remedies. And in the law, when we talk about a legal remedy, we really mean money. Money remedies. They award money. The other type of courts were called equity courts. And whenever you hear equitable or equity in the law, what that really refers to is fairness. And so what courts of equity did were they were there when you wanted a party to do or to not do something. Today we refer to these as injunctions for injunctive relief. So say your neighbor decides to build a fence and you determine that the neighbor is building the fence on your property, maybe 2 feet onto your property. What you can do is go to a court and say, "Court, tell this person to stop building the fence and then remove the fence that she has built." So we can go to a court and the court can order people to do or not do something. And historically those were divided into two branches. But that was all combined sometime in the early part of the 20th century. What are the differences between the civil law and the common law? Now, we've discussed a number of these differences already. And in fact, what I've decided to do is to not address those differences within this lecture, but I'm going to prepare a separate lecture on comparing civil law and common law. I've got a document online where you can find a chart that I've prepared, and I'll go over that chart online in a separate document. We can talk about what are those key differences and what are the similarities. So we can compare some of those key differences between the civil law and the common law. So in conclusion, what did we learn? The study of different legal systems is known as comparative law. That the civil law and the common law are two important legal systems. And honestly, at one point in time, if you took a course on comparative law, that's all you would have compared was the civil law and the common law. What we have decided now, eventually in the 21st century, is that Islamic law, which applies to a fourth of the citizens of the world, should be covered as well. But the civil law and the common law remain the two dominant legal systems, and they're present around the world. And finally, as I'll discuss in this separate lecture, there are key differences between the civil law and the common law. And that's it. Thank you.